Private Members' Business, Notice Number 1, Foreign Death Penalty Offences Preventing Information Disclosure Bill 2015.
I call the honourable member for Fairfax.
I present the Foreign Death Penalty Offences Prevention Information Disclosure Bill 2015 and its explanatory memorandum.
The bill is being run to the clerk. Clerk.
First reading, a bill for an act to prevent the disclosure of information by public officials in circumstances that may lead to the imposition of the death penalty in foreign countries and for related purposes.
I call the honourable member for Fairfax.
I move that this bill be now read a second time. Policing relies on trust and community support. In considering this bill, I will set out for the House the true facts and circumstances of the Bali Nine. We can only imagine how the father of one of the Bali Nine is feeling following his decision to do the right thing based on legal advice of his barrister to approach the Australian Federal Police to report breaches of Section 541 of the Queensland Criminal Code and breaches of Section 11.5 of the Commonwealth Criminal Code of 1995. In the terms of Section 541 of the Criminal Code of Queensland, a conspiracy to commit a crime carries a term of imprisonment of 7 years. Why then did the AFP fail to carry out its duty to arrest Scott Rush and allow him to leave Australian jurisdiction without being arrested, knowing he was likely to face the death penalty in Indonesia? Why did the Indonesian authorities not allow the Bali Nine to be arrested in Australia? Australian courts refused to extradite a person to face the death penalty in a foreign land. Why then should public servants and politicians not be held accountable to the same standard as Australian courts and Australian justice? Passing this bill will hold them to that standard and protect and defend the lives of all Australians. The government and the opposition must allow a free vote on this bill. Australians demand it. It seems to me that the AFP office committed a serious malfeasance when they failed to carry out their duty to arrest the Bali Nine in Australia, when they knew that they had committed a serious crime in Australia. I seek leave of this House to table copies of letters written to the AFP to the Indonesian National Police on the 8th of April 2005 and the 12th of April 2005.
Is the motion seconded? Oh, I'm sorry. You've asked leave to
Table.
To table. Is leave granted? Leave is granted. I'm sorry.
Which, contrary to the information given in the course of the recent AFP media presentation, demonstrate that the AFP was aware no later than the 12th of April 2005 of the identity of 8 of the Bali Nine. Contrary to what has been said in the course of the AFP press conference, they knew that the drug involved was heroin. They had detailed particulars of how the drug was to be carried, the part that was to be played in the operation by Chan. Multiple legal advice confirms the AFP had sufficient evidence to arrest Scott Rush on a charge of conspiracy prior to him leaving Australia. The AFP officers who failed to take such action should in the circumstances resign as officers of the AFP, as they have destroyed the trust of the Australian public and had in the AFP to act honourably at all times and put the lives of Australians ahead of any other matter, and uphold Australian law in Australia. The AFP didn't act honourably when acting on information provided by Scott Rush's father. The AFP letter sought the cooperation of the Indonesian authorities with a view to allowing all 8 of the couriers to return to Australia, subjecting the identified 8 to Australian law. Indonesian law enforcement authorities had no regard for the AFP's plan and were more interested in arresting them in Indonesia. Was it a fight over promotions? One wonders how the AFP can trust Indonesian authorities in the future. It's almost inexplicable that the paragraph numbered 4 on the AFP letter was included. One would have thought it might have even been included in an error. Of course, the AFP made it clear that it was not, and included by way of error. A deliberate decision was made to expose all 8 to the death penalty in Indonesia. It would appear the Deputy Commissioner was uneasy about the decision not to enforce Australian law in Australia. It was made clear during the AFP press conference that there was one AFP officer not prepared to participate in this decision. That was certainly in recognition of the fact that the AFP was aware of the likely fate of the participants in the operation. If the AFP were acting in accordance with the principles that Australians hold dear, they would not have deliberately exposed an Australian citizen to the death penalty. The assertions made by the AFP that they would act again, as they did in 2005, would indicate that legislation is required to ensure that the AFP firstly carries out its duty under Australian law and arrests people in Australia who have broken the law in Australia and not allow them to leave the country, as they did in this occasion. And secondly, to ensure the law carries sanctions if they act contrary to Australia's position, as they did in this case, and expose Australian citizens to the death penalty. Since 1973, the passage of the Death Penalty Abolition Act 1973, the death penalty is not applied in respect of offences under law of the Commonwealth of the Territories. Similar state legislation has outlawed the practice in the remaining Australian jurisdictions. On the 11th of March 2010, with bipartisan support, the Commonwealth Parliament passed the Crimes Legislation Amendment Torture, Prohibition, Death Penalty Abolition Act. The Act amends the death penalty to extend the current Commonwealth prohibition on the death penalty to all states and territories. This forecloses the possibility of any individual state jurisdiction reintroducing the death penalty. On the 2nd of October 1990, Australia confirmed at an international level its opposition to the death penalty by ratifying the second operational protocol of the International Covenant of Civil and Political Rights aiming at the abolition of the death penalty. The protocol entered into force as international law on the 11th of July 1991. More recently, on the 19th of December 2007, Australia sponsored and voted in favour of a landmark United Nations General Assembly resolution which called for the immediate moratorium of executions as a first step towards the universal abolition of the death penalty. More than half the General Assembly was prepared to vote in its favour. Faced with the prospect of execution of some of our citizens abroad, the Australian community has increasingly been forced to grapple with the question: what does it mean to be opposed to the death penalty in a region where our neighbours and allies continue to shoot and hang people? Questions have been raised, for example, about the AFP practical guide to international police-to-police assistance in potential death penalty situations, which allows the AFP to provide assistance to foreign law enforcement agencies in death penalty cases up until the point that a person is detained on charges or charges are laid, and even beyond the point with ministerial approval. Is it consistent with Australia's opposition to the death penalty to allow the AFP to work cooperatively with foreign law enforcement agencies in the investigation of offences which carry the death penalty, knowing that a provision of that assistance and information may ultimately lead to the charge, conviction and eventual execution of Australian citizens? Questions have also been raised about whether the Mutual Assistance Act should, as it currently does, allow the Attorney-General a broad discretion to authorise the provision of mutual assistance in death penalty cases, or if he or she is satisfied that circumstances exist. The term special circumstances is not defined in the Act. Both sides of politics have provided an inconsistent and unequivocal approach to the provision of agency-to-agency assistance in the death penalty cases. In its current form, the new guide perpetuates rather than remedies this anomaly. Only legislative approach will be the approach required to put the matter beyond question. Guidelines can change, as we've seen with the change of ministers, as we've seen with the change of government. Australians expect more from the Parliament.
Is the motion seconded? I call the honourable member for Indi.
Thank you, Madam Speaker. Yes, I'm happy to second the motion and reserve my right to speak.
The question is that the bill be read a second time. The time allotted for this debate, if there is no further speakers, has expired, and the debate is adjourned, and the resumption of the debate will be made in order of the day for the next sitting.